Ever get that sinking feeling when you fall behind on payments? Like, say, for your car?
Yeah.
It's stressful,
For
right?
sure.
And the thought of repossession can be downright terrifying.
It is.
But what if I told you there are legal safeguards in place?
Really?
Tools you can use to protect yourself and maybe even turn the tables in your favor.
Interesting.
Today, we're diving deep into repossession laws, specifically focusing on two powerful acts:
Okay.
the Uniform Commercial Code, or UCC,
Mm-hmm.
and the Fair Debt Collection Practices Act, or FDCPA.
Got it.
We're going to unpack how these laws work, so if you ever face a repossession situation,
Yeah.
you'll be armed with the knowledge to navigate it effectively.
Sounds good.
Our trusty guide for this deep dive is a collection of legal guides
Oh.
focused on winning repossession cases.
Winning repossession cases.
Yeah.
You know, it's interesting you mentioned that feeling of powerlessness.
Really?
So many people just assume they have no recourse when facing repossession. But the reality is the law provides significant protections for consumers.
I see.
Think of it this way. Both sides have to play by the rules.
Okay, so let's lay down those rules.
Sure.
What exactly do the UCC and FDCPA cover when it comes to repossession?
Well, the UCC is essentially the rule book for buying and selling goods.
Okay.
It covers everything from contracts to warranties to, yes, repossession in the context of repossession.
Right.
The UCC dictates how and when a creditor can take back an item if you default on your payments.
Gotcha.
It's designed to ensure fairness and prevent creditors from acting like the repo men in those cheesy action movies.
No more midnight raids and smashing through garage doors.
Haha, no, hopefully not.
That's a relief.
Yeah.
But what about those debt collectors we hear horror stories about?
Oh, yeah, those.
The ones who harass and threaten people?
Uh-huh.
Is that where the FDCPA comes in?
Absolutely.
Yeah.
The FDCPA is like a shield against those nasty debt collection tactics.
I like that, a shield.
Yeah.
Okay.
It prohibits things like harassment threats, misleading statements, and contacting you at unreasonable hours.
That makes sense.
Think of it as your legal guardian against those who try to bully you into paying.
So it's not just about preventing illegal repossessions,
Right.
but also about ensuring ethical and fair debt collection practices.
Exactly.
That's good to know.
Yeah.
But let's dig deeper into the UCC.
Okay.
What are some specific examples of how it protects consumers during a repossession?
One of the most important protections is the concept of breach of peace.
Breach of peace.
Yeah.
What's that?
This means a creditor can't use force, intimidation, or even enter your property illegally to repossess an item.
Oh.
It must be a peaceful process, and they can't do anything that would cause a public disturbance or endanger anyone's safety.
Gotcha.
For example, if a creditor tries to repossess your car
Yeah.
by towing it from your closed garage without your permission.
That's messed up.
Yeah, that would be a breach of peace.
So they can't do that.
Nope. The source material actually highlights several cases
right.
where creditors got in trouble for doing just that.
Wow.
And in those situations, you have legal recourse to fight back.
So knowing this, what are some things you can do to protect yourself if a repo agent shows up at your door?
First and foremost, stay calm.
Stay calm.
Yeah, remember, they're not allowed to use force or intimidation tactics.
Right.
You have the right to ask for identification and documentation, proving their authority to repossess the item.
Oh, that's smart.
Yeah. If they can't provide a proper credentials or if they start getting aggressive, you can refuse to let them take the item and contact the police if necessary.
That's empowering.
Yeah, it is.
Knowing these specific steps can make a huge difference in how you handle the situation.
For sure.
So it's not just about understanding the law in theory,
Right.
but knowing how to apply it in real-life scenarios.
Exactly.
And it's not just about how they take the item, but also what they do with it afterwards.
That's right.
Okay.
The UCC also mandates commercial reasonableness.
Commercial reasonableness.
Yeah, when it comes to selling a repossessed item.
Got it.
This means the creditor has to make a good faith effort to sell the item for a fair price to recover their losses.
So they can't just sell it for pennies on the dollar to a buddy or something.
Nope. They can't intentionally undervalue the item to spite you or make a quick buck.
Okay.
They have to act in a commercially reasonable manner.
Gotcha.
Which usually means selling it through a public auction or a reputable dealer.
That makes sense.
And here's where it gets interesting.
Okay.
You can actually challenge the sale price of a repossessed item.
What?
Yeah.
Really?
If you believe it was sold for significantly less than its fair market value.
That's good to know.
This is especially relevant for larger assets like cars or boats.
Wow. I bet a lot of people don't know they have that option.
Probably not.
So what steps could someone take if they think their repossessed car was sold for a suspiciously low price?
Well, the first step is to gather evidence.
Evidence.
Yeah.
Okay.
This might involve researching the typical market value of similar vehicles or getting an appraisal.
Got it.
If you have strong evidence that the sale price was significantly below market value, you can contact an attorney specializing in consumer law.
Okay.
They can help you determine if you have a valid legal claim and guide you through the process of seeking compensation.
It's like those home renovation shows where they find hidden treasures behind the walls.
Yeah.
You might be able to uncover some legal leverage by digging deeper into the details of the repossession and sale.
That's a good analogy.
This is fascinating stuff.
It is.
But before we get too carried away with repossession strategies, let's circle back to those all-important notice requirements.
Right.
What are some key things listeners should know about how creditors have to communicate with them during the repossession process?
One of the most common mistakes creditors make is failing to provide proper notice. Yeah. The UCC is very specific about the type of notice required, the method of delivery, and the time frame involved. For example, in many states, creditors have to give you written notice at least 10 days before they can repossess your car.
So 10 days notice.
At least 10 days in many states.
Wow.
And if they plan to sell the car after repossession, they usually have to send you another notice about the sale.
Another notice?
Yeah, giving you a chance to reclaim the car before it's sold.
So if they don't follow these notice requirements to the letter, does that mean you automatically win the case?
It's not quite that simple.
Oh, okay.
But it does give you a strong legal argument.
I see.
If you can prove that the creditor failed to provide proper notice, it can potentially invalidate the entire repossession.
Entire repossession?
Yeah.
Wow.
And even if it doesn't completely overturn the repossession, it can still give you leverage to negotiate a better outcome.
I'm starting to see a pattern here. Knowledge is power, right?
Absolutely.
The more you know about your rights under the UCC, the better equipped you are to challenge unfair or illegal repossession practices.
Exactly.
But I'm curious, what are some common pitfalls people should avoid when dealing with creditors and repossession agents?
One of the biggest mistakes people make is ignoring communication from creditors.
Really?
Yeah. It might be tempting to just bury your head in the sand and hope the problem goes away, but that can actually make things worse.
So even if those phone calls and letters are stressing you out, it's better to engage than to ignore them.
Exactly. By opening lines of communication, you might be able to work out a payment plan, negotiate a temporary forbearance, or even explore alternative options like voluntary surrender.
Voluntary surrender.
Yeah.
Okay.
Remember, creditors don't always want to repossess.
That's true.
It's usually a last resort.
Right.
They'd much rather work with you to find a solution.
Makes sense.
But if you ignore them,
they have no choice but to proceed with repossession.
That's a great point.
Yeah.
It's easy to get caught up in the fear and anxiety of the situation.
I know.
But taking a proactive approach and communicating with the creditor can sometimes lead to a more favorable outcome.
Definitely.
Okay, so we've covered some key protections offered by the UCC.
We have.
But before we move on to the FDCPA and its role in fighting unfair debt collection practices, I want to touch on something you mentioned earlier. Voluntary surrender.
Oh, yeah. What does
that entail, and how does it differ from repossession?
Voluntary surrender is essentially what it sounds like.
Okay.
It's when you proactively choose to return the item to the creditor instead of waiting for them to repossess it.
Okay.
There can be strategic advantages to this approach.
Like what?
For example, it can potentially minimize damage to your credit score.
Oh, that's good.
Yeah. And reduce the amount you owe in fees and collection costs. So it's like taking control of the situation rather than letting the creditor dictate the terms.
Exactly. It's a way of saying, okay, I'm facing financial difficulties and I'm willing to cooperate, but I want to do this on my terms.
That makes a lot of sense.
Yeah.
Okay.
Of course, it's essential to weigh the pros and cons carefully and consult with a financial advisor or attorney before making any decisions.
That makes sense. It's about making informed choices.
Right.
Rather than feeling trapped or helpless.
Yeah.
This whole conversation is really highlighting the importance of understanding your rights and options.
Definitely.
Okay, so we've delved into the UCC and its role in ensuring fairness during repossession.
I have.
Now let's turn our attention to the FDCPA.
Okay.
What are some specific ways this act protects consumers from those dreaded debt collection nightmares?
The FDCPA is a powerful tool for combating abusive debt collection practices.
I see.
It outlines a long list of prohibited actions, ranging from harassment and threats to misleading statements and false representations.
Gotcha.
For example, a debt collector can't call you repeatedly at unreasonable hours.
Oh, good.
Use obscene language.
Right.
Threaten to arrest you.
They can't do that.
Nope. Or lie about the amount you owe.
So no more ringing your phone off the hook at 3 a.m. or threatening to throw you in jail if you don't pay up immediately.
Exactly.
That's a relief.
Yeah.
But what if they're more subtle about it? Like, what if they try to trick you into paying more than you actually owe?
That's where the FDCPA's provisions against deceptive practices come in.
Deceptive practices.
Yeah.
Okay.
Debt collectors are prohibited from misrepresenting the amount you owe, falsely claiming to be attorneys or government officials, or threatening legal action that they have no intention of taking.
That's sneaky.
It is.
Okay.
They also can't falsely imply that you've committed a crime or that they'll damage your credit score if you don't pay.
So it's not just about blatant threats and harassment, but also about preventing more subtle forms of manipulation and deception.
Precisely.
No.
The FDCPA is designed to ensure that debt collection practices are fair, transparent, and respectful.
That's good.
Yeah.
And if a debt collector crosses the line, you have legal grounds to fight back.
That's right.
This is so empowering.
It is.
Knowing about these specific protections can really change the dynamic when dealing with debt collectors.
Sure.
It's like having a legal arsenal at your disposal.
I like it.
But what if you're unsure whether a debt collector's actions actually violate the FDCPA?
That's a good question.
Are there any telltale signs that should raise red flags?
Absolutely.
Like what?
One red flag is receiving communication from a debt collector about a debt you don't recognize.
Oh, that's scary.
It is.
What should you do?
Always demand validation of the debt in writing.
In writing?
Yeah.
Okay.
This means the collector has to provide you with documentation proving that you actually owe the debt and outlining the amount the original creditor and any fees or interest that have been added.
So it's like saying, show me the receipts.
Yeah.
I'm not just going to take your word for it.
Exactly.
Another red flag is if the collector refuses to provide you with their contact information or the name of the original creditor.
Right. They're legally obligated to provide you with this information.
Okay, good.
And if they start pressuring you to make a payment over the phone without giving you time to review the debt validation or consult with an attorney.
Yeah, that's sketchy.
That's a big red flag.
Red flag.
Remember, you have the right to pause the conversation, seek legal advice, and make informed decisions.
Right.
Don't let them bully you into making hasty choices.
This is such valuable advice.
It is.
I can already feel our listeners becoming more savvy and empowered.
Good.
But before we dive deeper into specific strategies for dealing with debt collectors, let's take a moment to summarize the key takeaways from this first part of our deep dive.
Okay, sounds good.
You've shared some incredible insights about the UCC and the FDCPA.
Glad to help.
But what are the most important things for listeners to remember as we move forward?
I'd say the most important thing is to remember that you have rights.
You have rights.
Yeah. Both the UCC and the FDCPA are designed to protect consumers from unfair and illegal practices.
That's good to know.
The key is to understand those rights.
Okay.
And be prepared to assert them.
How do we do that?
Don't be afraid to ask questions, demand clarification, and seek legal assistance if you need it.
Fantastic advice.
Thanks.
It's like that old saying, knowledge is power.
It's true.
The more you know about these laws, the more confidently you can navigate these challenging situations.
For sure.
And that's what the deep dive is all about.
What's that?
Equipping you with the knowledge and tools to take control of your financial well-being.
That's what we're here for. We've talked about knowing your rights, but what happens when those rights are violated? It's natural to feel intimidated by the idea of going up against a creditor or debt collector in court.
Yeah, that's scary.
But remember, these laws have teeth.
Okay, so let's say someone believes their rights were violated during a repossession. They've got a case, right?
Potentially.
But how do they actually build a strong legal argument and navigate the complexities of a trial?
It's not just about showing up and saying, hey, they wronged me. You need a solid strategy, and a good attorney can be invaluable in guiding you through this process.
Okay, so like a game plan.
Exactly. Think of it like building a case brick by brick.
So what are some of the key building blocks of a strong repossession case?
One of the most crucial phases is discovery.
Discovery.
This is where your attorney gathers all the relevant documents and evidence related to the repossession.
Okay, what kind of documents?
Things like the original loan agreement, payment history, notices of repossession and sale.
Gotcha.
And any communication between you and the creditor.
Sounds like detective work.
It kind of is.
Is the goal to catch the creditor in a lie?
Well,
Or expose some shady practices?
it's more about uncovering inconsistencies, procedural errors,
Right.
or any evidence that the creditor didn't follow the rules outlined in the UCC or the FDCPA.
I see.
These documents can reveal crucial details.
Like what?
Did the creditor properly notify you before repossession? Did they sell the repossessed item at a fair price?
Right.
Was there any evidence of harassment or deceptive practices by debt collectors?
So you're looking for any slip-ups?
Exactly. Each document is a piece of the puzzle.
So it's not just about what happened,
Right.
but also about how it happened.
Yeah.
And whether the creditor followed the proper procedures every step of the way.
That's the key.
But what about those situations where the law seems a bit murky? Like, what constitutes a fair price for a repossessed item?
That's a good point.
That seems subjective.
That's where expert witnesses can play a crucial role.
Okay, how so?
Imagine you're arguing that your repossessed car was sold for a suspiciously low price.
Okay, yeah. An expert witness, like a certified appraiser, can analyze the sale price and compare it to the market value of similar vehicles.
Oh, so they can determine if it was actually a fair price.
Exactly. And their expert testimony can be incredibly persuasive in court.
So they can provide that objective third-party validation to support your claim.
Exactly. It's like having a specialist on your side to back up your argument.
I like it, but let's say we've gathered all the evidence.
Okay.
We've got our expert witnesses lined up, and we're ready for our day in court.
Right.
What happens during the trial itself?
Think of the trial as the culmination of all your preparation.
Okay.
It's where you present your case to the judge or jury,
Right.
explaining how your rights were violated and why you deserve compensation.
Gotcha.
Your attorney will present the evidence, call witnesses,
Okay.
and make legal arguments based on the UCC and the FDCPA.
It sounds a bit like a legal performance.
In a way it is.
But what about the other side?
Oh, yeah. Don't they get a chance to present their version of events?
Absolutely. The creditor or debt collector will also have an attorney who will present their side of the story.
Okay.
They'll try to refute your claims, challenge your evidence,
Right.
and minimize the significance of any violations.
So it's like a back and forth.
It can be very much so.
Okay. So it's like a legal battle with each side trying to convince the judge or jury that their version of events is the correct one.
It's a battle of narratives, for sure.
But what role does the listener, the person who's been wronged, play in all of this?
Your role is to work closely with your attorney,
Okay.
providing them with all the necessary information and documentation,
Right.
and being prepared to testify truthfully and accurately about your experiences.
So it's a collaborative effort.
Absolutely.
You're not just a passive observer in this process.
No, not at all.
You're an active participant working with your attorney to fight for your rights.
Exactly. And remember, even if you have a strong case,
Yeah.
going to trial can be expensive and time-consuming.
Oh, yeah, for sure.
That's why many cases end up settling out of court.
Really?
In fact, the threat of a trial can sometimes be enough to motivate the creditor or debt collector to offer a favorable settlement.
So it's like a strategic game of chess. You're not always aiming for a checkmate,
Right.
but rather positioning yourself to achieve the best possible outcome.
Precisely. And a skilled attorney can help you navigate these complexities and negotiate effectively on your behalf.
That's why it's so important to have a good lawyer.
They can make all the difference.
They can explain your options, assess the risks and benefits of going to trial,
Yeah,
and ultimately guide you toward a resolution that meets your needs.
exactly. That's the goal.
This whole conversation is really highlighting the importance of having a trusted legal advocate in your corner during these situations.
It's essential.
Someone who can translate the complexities of the law into a clear and actionable strategy.
I agree. But before we move on to the third part of our deep dive, where we'll explore those real-world examples and template letters you mentioned earlier.
Right, those cheat codes.
Yeah, exactly.
I'd like to ask you a more personal question.
Sure.
What motivates you to fight for consumer rights in this area of the law?
You know what really drives me is seeing the impact these cases have on people's lives.
Really?
Repossession can be a devastating experience,
Yeah.
both financially and emotionally.
I can imagine.
People lose their transportation, their livelihoods, their sense of security.
That's awful.
It is, and When I can help someone navigate this challenging situation, hold a creditor accountable, and maybe even get them some compensation, it's incredibly rewarding.
That's great.
It's about more than just winning a case. It's about empowering people and making a difference in their lives.
That's inspiring, and I think it speaks to the heart of what the deep dive is all about.
What's that?
We're not just here to provide information. You're here to empower you, our listeners,
That's right,
to take control of your situations, to know
Yeah,
your rights.
absolutely, and to fight for what's fair.
That's what we're all about.
All right, let's shift gears from the courtroom drama and get down to some practical tools you could use right now.
Sounds good.
I'm talking about those real-world examples and template letters you mentioned earlier.
Right.
These sound like they could be game changers for anyone facing repossession.
They can be.
Okay, map in hand. Let's navigate.
Okay.
Where do we start?
Let's revisit that breach of peace scenario.
Okay.
Where a creditor illegally enters your property to repossess an item.
Right, like breaking into a garage or something?
Exactly. Remember that case where the creditor barged into a locked garage at night?
Oh, yeah, that one.
That's a clear violation of the UCC, and you can use that to your advantage.
So instead of panicking, you can pull out the UCC rulebook and say, hey, you can't just break in and take my stuff.
Exactly. Our source material provides a template letter specifically for this situation.
Oh, wow.
It lays out the legal basis for your claim.
Stating how the creditor's actions violated the UCC's breach of peace provision.
So it's like having a legal expert whispering in your ear, guiding you on what to say and how to say it.
It is.
That's powerful.
You can use this letter to demand the return of your property compensation for damages.
Gotcha.
Or even leverage it to negotiate a more favorable payment plan.
But what about those situations where the creditor seems to be following the letter of the law, but their actions still feel shady?
Right.
Like, what if they repossess your car without giving you proper notice?
Yes. The failure to provide proper notice scenario.
That's a tricky one.
Remember, the UCC has strict requirements regarding notice of repossession and the subsequent sale of your property. If the creditor skips a step or misses a deadline, it weakens their position and strengthens yours.
So if you find yourself in that situation, what can you do?
Again, our source material has you covered. It includes a template letter specifically for challenging a repossession based on improper notice. This letter outlines the specific notice requirements outlined in the UCC and explains how the creditor failed to meet those obligations.
That's like a step-by-step guide.
Exactly. You can use this letter to demand the return of your property, argue for a reduction in the amount you owe, or even potentially invalidate the entire repossession.
These template letters are starting to feel like cheat codes for dealing with creditors.
I can see that, but I imagine they're most effective when combined with thorough documentation, right?
For sure.
Always keep detailed records of all communication with creditors and repossession agents.
Good advice.
This includes saving all letters, emails, text messages, and even voicemails.
Okay, so every little scrap of communication.
Exactly. These records can serve as evidence to support your claims and demonstrate that you were proactive in asserting your rights.
It's like building a fortress of evidence to protect yourself.
I like that analogy.
So we've got our legal foundation, our cheat codes in the form of template letters, and our fortress of documentation. What's the final piece of the puzzle?
The final piece is knowing when to seek professional legal advice.
Okay, when would that be?
While these templates and strategies can be incredibly helpful, every situation is unique.
Right.
If you're facing a complex repossession case, or if you're unsure about how to proceed, it's always best to consult with an experienced attorney who specializes in consumer law.
That's probably a good idea.
They can assess your specific circumstances, tailor a strategy to your needs, and guide you through the legal process.
It's like having a seasoned guide to help you navigate the sometimes treacherous terrain of the legal system.
Exactly.
Well, we've covered a lot of ground today.
We have.
From the theoretical underpinnings of the UCC and FDCPA to practical tips and real-world examples.
It's been a great discussion.
I'm feeling empowered, and I hope our listeners are too.
Me too.
Any final words of wisdom for our deep divers before we wrap up this episode?
Remember, you don't have to face these situations alone.
That's important.
Knowledge is your most powerful weapon.
Knowledge is power.
And resources are available to help you.
Good to know.
Don't be afraid to reach out to legal aid organizations, consumer protection agencies, or qualified attorneys.
Yeah.
You have rights, and you deserve to be treated fairly.
Beautifully said. And on that note, we'll resurface from this deep dive into repossession laws.
Back to the surface.
But remember, this is just one example of the many consumer protection laws out there designed to safeguard your rights.
That's right.
So stay curious, stay informed, and never stop advocating for yourself.
Couldn't have said it better myself.
Until next time, deep divers.